Hey everybody, it's Phil with Arate Law. I want to go over a document and walk you through how to do this on your own because it's an important document, but it's also a document that I think you can complete on your own. You don't really need an attorney for this one. This is basically you just filling out a lot of the information yourself and kind of just walking through it. It's a short document. It's pretty straightforward. Not a lot of legalese in here, so it's pretty easy for you to do on your own. So that's why I'm making this video. I'm also going to make this specific template available on my website for download so you can download it and do it yourself. And it's an advanced healthcare directive, also known as a power of attorney for healthcare. And what that is a lot of people know what a power of attorney is for your financials, for your estate, and stuff like that. This basically gives someone, an agent, the ability to make decisions for your healthcare on your behalf. And it's an incredibly powerful document because it gives the agent a lot of power to make these healthcare decisions and act as if it was you. And that's what a power of attorney does, to give someone that ability to make those decisions as if they were you. It does not, as a lot of people say, it does not make you a temporary attorney. A lot of people think that power of attorney gives you the ability to represent them in court and stuff like that. That's not what a power of attorney is. Basically just gives people the ability to act on your behalf and sign documents, or when it comes to property and financial stuff like that, sign documents, execute things. And in this certain case, it gives you the ability to speak with healthcare professionals and make those healthcare decisions for someone who may be incapacitated and can't make these healthcare decisions. It's a document that a lot of people feel like it's not very necessary. Maybe younger parents with kids and stuff like that don't really think it's necessary because they think, well, I'm young, I'm probably going to live for a lot longer. I don't really need to worry about this. But the sad thing is things do happen. It's better to have one than not. And this shouldn't take too long for you to fill out. I do urge you to take your time with this, though, and to sit down and figure out exactly how you want this to be structured. Take your time, speak with loved ones, spouses, parents, all that stuff. Because it is an incredibly important document. And like I've always said to my estate planning clients, the more specific you are now reduces the burden and any tension and strife and stress that you're going to leave on loved ones if anything happens. And that's really what you want. You don't want to create all this strife and tension between people, especially with healthcare directives. There's a lot of emotions running high on what happens in the sense of you may have parents or your in-laws, if you're the spouse, children might get involved, and everybody has a say in what they want to happen. So a document like this gives someone the ability to make those decisions on your behalf, and it makes it a little bit easier on everybody else because it puts one person in charge, and that one person knows exactly how you want things to be done. It also lists out your wishes, how you want whether you want your disposition of remains to be, you want to be an organ donor, how you want to be disposed of, stuff like that, whether you want an autopsy, whether you want to prolong life. But we're going to get into all that, and I just want to jump right into it right now. Again, this is going to be available on my website, so you can go there and download from a link, and let's jump right into it. So the first thing, which is obviously the most important thing, and I just want to say on this specific template, this is a good template. It's professionally written. It's well drafted. It has a lot of statutory language in it, which is important for people who are going to read your advanced healthcare directive. They can recognize the language. It's just well written and straightforward. So that's why I picked this specific document. I'm sure there's a lot of them. If you Google them, there's hundreds of them out there, which one you want. But this is specific to California probate codes. So you want to make sure you get one that's really specific and has really good legal binding effect. And I think this one really fits the bill. So this first part, power of attorney. This is the simple, straightforward part. You're going to name someone to be your power of attorney and make that decision when it comes time for your health care. The one thing I always recommend is you talk to the agent of who you're going to nominate. A lot of times people will just throw a name in there and figure that they'll figure it out later. It's better you talk to the person, make sure they even accept that they want to be your agent. There may be some people you name who say, I don't want that burden. I don't want to make those decisions on your behalf. I'd rather not. So make sure you at least give them a call, talk to them and say, hey, I want to name you my agent for my power of healthcare, power of attorney for healthcare. And then if they say, yeah, that sounds great, then at least they know and they're on the they're aware of it, so in case anything happens, they can spring into action, which is what you want them to do. The other thing that I always tell a lot of my estate planning clients, and they say this is optional, but I would say it's absolutely mandatory, is you want to name alternatives. And the reason for that is because you don't want to put all your eggs in one basket. And you may trust that first person, you may think they'll be there forever. But again, things do happen, and maybe that person, you have a falling out, or they move to a different country and they don't want to help, or something happens to them that they're actually unable to fulfill their duties. So it's better to spread it out and have backup plans and contingency plans in case something happens. So if the first agent can't do what they need to do, you have people who can also jump in. Same advice. Make sure you talk to these people, let them know that they're going to be the first alternate or second alternate, and just say, just in case agent one can't do it, you're up to bat, or you're in the lineup just in case, so that they're aware of it as well. Get down here at agent's authority. Basically, you're authorizing them to make all your healthcare decisions. This is where the power of attorney really comes in. To make all these decisions about your nutrition, your hydration, other forms of healthcare, and then you can insert what are called specific instructions. And specific instructions are if you want to add certain things to direct the agent or let them know how you want things done. This one is pretty important. Do you want it to start immediately, or do you want it to start when you become incapacitated? By checking this box, you're saying that you want it to start immediately. This is more appropriate for maybe elderly clients or people who are in and out of healthcare, and they don't want to make a lot of these decisions themselves, and they want someone else to start making decisions for them. This is probably not applicable to the younger client or someone who, feels like they're maybe in their 40s or 50s and they feel healthy and they don't really need to worry about someone making their healthcare decisions, because it doesn't make sense, if you're young and healthy, why you would want someone to be making your healthcare decisions for you right now. So that's an important one. That basically says, do you want it to start now or start later? Agent's obligation. This basically says you want someone, your agent, and this is another reason why you want an agent who you are close with, who you trust, who knows you really well. You want them to make the decisions in your best interest, and that gives them a lot of power to determine. If it's not in this document, they can determine based on your best interest, as if they were you, to make these healthcare decisions for you. And they got to consider everything, your personal values, maybe your religion, stuff like this is important. So it's important to name someone who's an agent who knows that stuff. Agent's post-death authority. Agent is authorized to make anatomical gifts, and this is detailed more in part 3, but this is basically, it gives them the ability to say, do you want to donate organs, authorize an autopsy? Again, a lot of times religious reasons people don't authorize autopsies. Decide disposition of my remains, and then part 3 goes into more of it. Nomination of conservator. If you are only executing this document, a conservator is important because it doesn't allow someone to be the conservator of your estate and handle certain things. Again, you want to kind of flesh this out more in other documents like a will and a trust. This is optional though. If this is the only document you want to make sure you get handled, you can nominate someone. Conservator just looks after your stuff and looks after your affairs. Same thing. If you're going to nominate someone, make sure they're aware of it, make sure they understand what they're getting themselves into, and make sure they agree to it. Down here, instructions for healthcare. This is really important. This is the part that a lot of people think about when they think of an advanced healthcare directive. They think that an advanced healthcare directive is basically a DNR, which it is part of it, but it's not all of it. And the reason I say that is because obviously you have all these other things that go into an advanced healthcare directive. This is just one part of it. And notice it's not optional. Part 2 is required in the sense that someone needs to make this decision for you. If you are incapacitated and you can't make these decisions, there was that famous case a long time ago out of Florida where they couldn't figure out, because there were no estate planning documents. It was a national story. It was a fight between the husband and the parents who wanted to keep her alive, who wanted to do a DNR or take her off life support. That was a big issue. All could have been solved with just this little bit of language, and everybody knew what was going on. So this is a simple decision whether you want to prolong your life. So if it looks like you're going to be, if there's a slim chance of medically or recovering medically, and you don't want to keep prolonging or being on life support, then you would choose this. You don't want to choose to prolong your life, or you would check if you want to prolong it as long as possible, then you would choose this one. So that's a big decision as well. Make sure you think about that as well. What's best on your family? What's best on the people around you? What they would think. A lot of people I know say, well, if I'm in a state where I don't think I'm ever going to recover, probably not best to prolong my life. But that's a decision you have to make. This one, a relief from pain, except as I state in the following space, I direct that treatment for alleviation of pain or discomfort be provided at all times, even if it hastens my death. That basically says, if you're sort of, best way to describe it, and I'm not a doctor, so I can't really describe it in the best way, but basically if it looks like you're at the end of the line and you're not going to recover from this, it does allow you to alleviate some pain. If you're in incredible pain or discomfort, that you allow the doctors to alleviate some of that pain, even if it does hasten your death, meaning at least if you are going to pass away and the doctors know you're going to pass away, you can choose that so that you can be administered some relief from the pain, even if it speeds things up. Other wishes is where you can designate specific things, whether they're religious reasons or personal values that you may have. This is where you get a chance to really get in there and decide how you want things done. Some people keep it, some people don't. You can add these specific instructions that your agent's going to have to follow. Part 3, donation of organs at death. Optional, because some people already have that they are an organ donor on their driver's license. They've already designated that. But at least this way, it does say that you can designate what you want, how you want it given, and what you want your organs given to. Some people want it for research only or education. Maybe you want to just make it for transplant for people who need, and you can just strike out any of these things, meaning you can strike them out or you can just delete them. Part 4, primary physician. So this is where you put in the name of your primary physician, your physician that you talk to, a physician that you know, usually the doctor that you go to all the time. Put their name and address down. And like what have I been saying throughout this entire video is you always want to pick an alternate. And the reason you want to do that is because you may designate a physician right now, but who knows? They may retire by the time this document goes into effect, and they may not be your primary physician anymore. So talk to your physician, ask them if there's anybody you would designate as an alternate physician. Maybe they have a recommendation of somebody. Say, hey, I'm coming up with my advanced healthcare directive. I've named you as my primary physician, but is there anyone I should name as my alternate? Last part is the execution formalities, and this is where you as the principal, this is where you put your name, your address, your city and state, and you sign, date and sign. And then you have 2 witnesses sign, and they have to read this, and this is basically what they're agreeing to, that under the laws of California, sign or acknowledge, they know that it is known, that this is an advanced healthcare directive. The individual they appear to be sound of mind, under no duress, that they are not the person appointed as agent by this advanced healthcare directive, which is important. You can't have the person you're appointing as agent be one of the witnesses, that you're also not their healthcare provider, and all these other things. So there are some things that you want to make sure that you follow those witness rules correctly. This right here, additional statement of witnesses, at least one of the witnesses must also sign the declaration. They're not related to individual except directive by blood, marriage, or adoption. And to the best of my knowledge, I am not entitled to any part of the individual's estate. So you have to have at least one witness who fits that description as well. Special witness requirement is just for people who are in skilled nursing facilities. And you want to make sure you get that signed. Again, this is why I like this form. Gives you the specific statutory language. And then the last part is notarization. You can have it notarized, you can have it just witnessed, you can have it just either one. I would suggest having it both. Again, be as thorough as possible. So with that, that's basically it. So take the time, look it over. Like I said, it's available up on my website. If you downloaded this from the website and you're watching this, to go through it and you have any questions, you can always reach out to me, phil@arate.law. Web address is www.arate or www.arate.law. And that's it. Enjoy.